210. Committee on the Judiciary, Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Without objection, the chair is authorized to declare recess of the subcommittee at any time. I welcome everyone to today's hearing on the need to enhance the Voting Rights Act practice-based coverage. Remind all members we have established an email address and distribution list dedicated to circulating exhibits, motions, other written materials members might want to offer. If you'd like to submit materials, they send them to email address that has already been shared with you, and we will distribute them to the members and staff as quickly as possible. Finally, I ask all members and witnesses, both those appearing in person and those appearing virtually, remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. As part of the subcommittee's longstanding efforts to revitalize the Voting Rights Act pre-clearance provision, today's hearing will focus on known practices coverage. Known practice coverage is also called practice-based coverage. It is a form of pre-clearance coverage that applies to certain voting law changes that have historically been associated with racial discrimination. H.R. 4, the John R. Lewis Voting Rights Act from the 116th Congress, contained such a practice-based coverage formula. Practice-based preclearance is a necessary complement to the traditional geographic coverage formula of the Voting Rights Act, addressing a gap potentially left by the traditional formula. As we will hear from some of our witnesses today, drawing from historical evidence, there's a strong relationship between certain voting laws and policies, such as strict voter identification requirements, the consolidation or relocation of polling locations, and changes to district or jurisdictional boundaries, and voting discrimination based on race, color, or language minority status. Moreover, historical evidence demonstrates that when the percentage of the minority racial or ethnic population of a state or county reaches a certain tipping point, there's an increased likelihood that jurisdiction will engage in a voting rights violation. That is, in areas where there is an emerging minority group that at some point grows large enough to threaten the existing white-dominated power structure of the jurisdiction, the risk is greatly heightened that the white-dominated power structure will respond by trying to suppress the ability of the members of the emerging minority group to vote. Or as Machiavelli said, power is not given, it's taken. This can be true even in jurisdictions that may not have a long history of engaging in voting rights violations and therefore would not be subject to preclearance under the traditional geographic coverage formula. In light of the lessons drawn from the foregoing historical evidence, H.R. 4 contained a practice-based preclearance formula that accounted for certain practices with an historical association with race discrimination in voting, while focusing this type of preclearance regime on those jurisdictions where the minority voting age population may be high enough to raise the substantial risk that the jurisdiction would engage in voting rights violations. Our hearings over the last 2 years provide an ample record to support the conclusion that certain practices like polling closures, redistricting that reduces minority representation, strict voter ID requirements, and reducing the availability of non-English language voter materials result in making minority citizens worse off with respect to their voting rights. These are among the covered practices under H.R. 4. Practice-based preclearance has the added potential benefit of applying to states and localities nationwide. In this way, it avoids picking and choosing a strategic set of jurisdictions to be subject to preclearance and is responsive to the Supreme Court's concern about ensuring the equal sovereignty of the states that this court expressed when striking down the VRA's former geographic coverage formula in Shelby County versus Holder. While a practice-based coverage formula would be novel, Congress has broad constitutional authority to act. 14th and 15th Amendments give Congress explicit legislative power to enforce voting rights and equal protection against purposeful race discrimination. These amendments form the basis of Congress's authority to pass the VRA, including its preclearance provisions in the first place. The Voting Rights Act was first challenged the year after its enactment. The Supreme Court in South Carolina v. Katzenbach upheld the preclearance provision and its coverage formula, holding the congressional authority to enforce the 15th Amendment is broad and comprehensive, and that implementing legislation must pass only a test of minimum rationality. This broad understanding of Congress's authority under the 15th Amendment remains the law. To the extent any of the covered practices affect federal elections, the Elections Clause, which confers ultimate authority on Congress to regulate the time, place, or manner of congressional elections further bolsters Congress's authority to implement a practice-based pre-clearance regime. The decision in Shelby County leaves undisturbed the broad understanding of Congress's authority under the Reconstruction Amendments and the Elections Clause to protect minority citizens against the denial or abridgment of the right to vote on account of race, color, or language minority status. And the record that the subcommittee has built over the last 2 years and continues to build with this hearing provides ample support for a practice-based pre-clearance regime. I thank our witnesses for being here. I look forward to their testimony. It is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. This is the subcommittee's 5th hearing in as many months regarding the Voting Rights Act. Voting rights is an important topic. No one disputes that, but we're wondering when we'll take up other important issues under the jurisdiction of this subcommittee. So today's hearing will focus specifically on the practice-based coverage provision in H.R. 4. I'm going to put this very simply. This overly broad and constitutionally suspect Democratic proposal aims to outlaw common sense voter integrity measures. Under the practice-based coverage regime, every state and political subdivision would have to pre-clear certain election practices, including changes to voter identification requirements and simple changes to voter registration list maintenance processes. This is a draconian step, and let's just be honest here, it's a clear attempt to federalize elections. As I've noted here many times before, the Election Clause of the U.S. Constitution gives state legislatures the authority to prescribe, quote, the times, places, and manner of holding elections. Voting is a fundamental right in the United States, and the 15th Amendment requires the states to ensure voting is accessible and available to every American. Congress passed the Voting Rights Act in 1965 to overcome state resistance and barriers that prevented minorities from exercising their right to vote, as is guaranteed by the 15th Amendment. But this was during the Jim Crow era. As Chief Justice John Roberts stated in Shelby County in that opinion that we talk about so often in here, the, quote, exceptional conditions at the time justified the, quote, extraordinary departure from the traditional course of relations between the states and the federal government. But that was at that time. In the same opinion, the court found the Voting Rights Act coverage formula to be outdated, finding that, quote, the conditions that originally justified these measures no longer characterize voting in the covered jurisdictions, unquote. If the record today does not support a new coverage formula, it most certainly does not support the sweeping practice-based coverage preclearance provision found in H.R. 4. One of our witnesses today, Mr. Russ Nobile, aptly concluded that if nationwide registration disparities did not justify nationwide preclearance coverage when the Voting Rights Act was originally enacted, it is very difficult to see what data from today supports imposing it now. This legislation is just another example of a politically motivated power grab that will enable partisan federal bureaucrats to control state election laws. We will likely hear from the other side of the aisle this practice-based coverage provision is needed because states have come up with innovative ways to, quote, suppress minority voters. That's all we hear about today. But that is a false and patently absurd argument. Today, it is easier for eligible Americans to vote than ever before in our nation's history. And to be clear, Republicans want every legally cast ballot to count. But the only way to make sure legal votes carry the weight they deserve is to prevent casting of illegal votes. One common sense way for states to do this is through voter ID laws. But under practice-based preclearance, states and political subdivisions would have to go to Biden's Justice Department or the courts to enact a simple voter ID law. Mandatory voter ID is an election integrity proposal that is very popular across the nation because it follows logic and common sense. A recent Monmouth poll found the overwhelming majority of Americans, 81%, support voter identification laws, including 62% of Democrats who participated in the poll. Furthermore, 34 states currently have some form of voter ID law on the books, and this includes many liberal states with provisions nearly identical to the ones Democrats are criticizing in the state of Georgia. H.R. 4 is wildly out of step with the facts on the grounds and with public opinion, and we should be considering ways to empower states to secure their elections rather than subjecting them to the whims of President Biden's radical bureaucrats. I do thank our witnesses for appearing today. We look forward to your testimony. I see we have students or interns here. We're glad you're here as well. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Johnson. Mr. Nadler has an opening statement, and Mr. Nadler's coming in just a second. While we're waiting for Mr. Nadler, could you name us some of those bureaucrats?
Yes, I can. How much time will you yield? It's the apparatus, Mr. Chairman.
The chairman of the full committee, Mr. Nadler of New York, is recognized for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, over the last few years, the subcommittee has focused much of its consideration of voting rights on the critical question of how Congress can revitalize the Voting Rights Act Section 5 geographic-based pre-clearance regime. And this remains a central challenge before us. Today's hearing gives us the opportunity to consider how requiring practice-based pre-clearance could serve as an additional means of achieving this end. The Supreme Court's decision 8 years ago in Shelby County versus Holder gutted the Act's geographic coverage formula, which determined which jurisdictions would be subject to pre-clearance. In striking it down, the court effectively rendered the pre-clearance provision inoperative. As has been documented by several of the witnesses who have appeared previously before the subcommittee, there remains a current need to remedy ongoing and widespread discrimination against minority citizens in voting. Voter discrimination did not simply disappear with the enactment of the Voting Rights Act. Indeed, discriminatory voting practices evolved in response to the Voting Rights Act, a process that has only accelerated over the past 8 years since the Shelby County decision. Thanks to the Voting Rights Act, overtly discriminatory devices like the literacy tests or poll taxes of the Jim Crow era are now gone. In their place, jurisdictions have sought to enact less overtly discriminatory voting practices that nonetheless target minority voters with surgical precision. These seemingly neutral voting practices, in fact, suppress minority voters, resulting in the denial of their right to an equal opportunity to participate in the electoral process and to elect the candidate of their choice. The currently defunct Section 5 pre-clearance coverage formula is geography-based. That is, it applies to jurisdictions with a history of voter discrimination. An updated geographic coverage formula that applies to jurisdictions with a documented history of voting rights violations would likely subject to pre-clearance many of the jurisdictions responsible for this new wave of voter suppression laws. But as we will hear from our witnesses today, this may not be enough to remedy the discrimination endemic to this new age of voter suppression brought on by the Shelby County decision. As our witnesses will describe, many jurisdictions with significant emerging minority populations do not have a documented history of voting rights violations. Yet these jurisdictions engage in certain specific practices with a proven historical association with discrimination, such as changing their electoral systems from single-member districts to at-large elections to limit the growing political influence of minority voters. One drawback of a history-based geographic formula is that it would not subject jurisdictions like these to pre-clearance, even though these specific practices result in discrimination against minority voters. A practice-based pre-clearance regime could address this gap in coverage by subjecting any jurisdiction that engages in these specific practices to pre-clearance nationwide. Indeed, I would note that H.R. 4, the aptly named John R. Lewis Voting Rights Act, which passed the House last Congress, contains both geography-based and practices-based coverage formulas. I would also point out that such a practice-based pre-clearance regime would be in keeping with the Supreme Court's reasoning in Shelby County, which struck down the current coverage formula partly because, in the court's view, the old coverage formula did not sufficiently justify the VRA's unequal treatment of the states. A practice-based coverage regime would avoid that constitutional concern by treating every jurisdiction equally nationwide. Moreover, as our witnesses today will testify, even under the court's decision in Shelby County, Congress still retains broad authority under the 14th and 15th Amendments, as well as the often overlooked Elections Clause, to pass a pre-clearance regime that reflects current conditions. As we consider ways to reinvigorate the Voting Rights Act, it is important to remember that the VRA reflects Congress' recognition that voting discrimination presents a unique harm that requires a powerful remedy. Decades of history since the Reconstruction era has taught us that despite our nation's progress, threats to minority voting rights remain ever present. The VRA's purpose has always been to thwart these constantly evolving threats to the right to vote, and Congress has amended the VRA on several occasions in the decades since its enactment to further adapt it to that purpose. The current attack on voting rights demands that Congress again take action to ensure that the Voting Rights Act continues to protect every American's right to vote. I thank Chairman Cohen for holding today's hearing, as it is another step toward that important goal. I look forward to the testimony from our witnesses, and I yield back the balance of my time.
Thank you, Mr. Nadler. Mr. Jordan does not have a statement, so we'll go to the witnesses. We welcome our witnesses and thank them for participating in today's hearing. I'll now introduce each of the witnesses, and after each introduction, we'll recognize that witness for his or her oral testimony. Please note that each of your written statements be entered into the record in its entirety. We summarize your testimony in 5 minutes. Most of you know the lights, the green, the yellow. You all have all been with us before. You're veterans. To help stay within limits, you've got your lights. For our witnesses testifying remotely, there's a timer in the Zoom view that should be visible on your screen. Before proceeding with the testimony, I remind you, tell the truth, nothing but the truth, the whole truth. And if you don't tell the truth, then you're in big trouble. Then you could be a false statement, you could be subject to prosecution under Section 1001 of Title 18 of the United States Code, so be sure and tell the truth. Our first witness is Mr. Thomas Sáenz. Mr. Sáenz is the President and General Counsel of the Mexican-American Legal Defense and Education Fund, otherwise known as MALDEF, a position he's held since August 2009. Prior to that, he served as counsel for then Los Angeles Mayor Antonio Villaraigosa? Exactly. Prior to that, Mr. Sáenz was a litigator for MALDEF for 12 years, and for 8 years he taught civil rights litigation as an adjunct lecturer at the University of Southern California Law School. Received his JD degree with honors from Yale, undergraduate degree summa cum laude from Yale, later served as law clerk to the Honorable Harry Hupp of the U.S. District Court of the Central District of California, and the Honorable Stephen Reinhardt of the Ninth Circuit in California. I believe you were with us in, was it Houston? Were you in Houston with us? No. There was somebody else from MALDEF then, but you've been with us before. You're now recognized for 5 minutes.
Push that button.
Thank you. Mr. Chair, Ranking Member, members of the committee, I am the President and General Counsel of MALDEF. Throughout MALDEF's 53-year history, we have engaged in litigation on behalf of voting rights. Since 1975, that litigation has primarily been under the Voting Rights Act. Since in 1975, it was extended to protect the Latino community throughout the United States. Based on that long experience, protecting the voting rights of Latinos in the country, I can tell you that practice-based coverage is a much-needed, essential complement to geographic coverage, particularly for the Latino community, given our ongoing and projected growth. Practice-based coverage is a complement, as you've stated, Mr. Chair, to the geographic formula. Each of them performs a different but essential role in ensuring that nationwide we can guarantee that voting rights are protected from intentional suppression and from suppression that has discriminatory effects. Each of them plays a role by ensuring that we are nationwide guaranteeing the right to vote provided in the 14th and 15th Amendment. Practice-based coverage is essential to the Latino community because of our ongoing growth and dispersion throughout the country. The simple fact is that Section 2 litigation under the Voting Rights Act, whether it's engaged by the Department of Justice or by private parties, is incredibly costly and time-consuming. The very name of the applicable court test, totality of the circumstances, gives a sense of how costly and time-consuming such litigation can be. If we were left with Section 2 as the only or primary means of addressing vote suppression in this country, we would fail as a nation in guaranteeing the voting rights under our Constitution. This is why we must supplement Section 2 litigation with preclearance. Preclearance has been justly recognized as the most powerful civil rights enforcement tool in our history, but it should also be recognized as an early and important form of alternative dispute resolution incorporated in federal law. Like all good ADR, it saves time and money. I should note that the primary benefit of those savings has been to cover jurisdictions themselves, because if those jurisdictions faced successful Section 2 litigation, they would not only have to absorb their own costs of defense, because of cost shifting and fee shifting, they would have to absorb the costs of the plaintiffs as well. That means that the primary savings from preclearance has and will continue to pertain to the covered jurisdictions themselves. Preclearance as ADR means that it can be invoked to address significant threats to voting rights across the country. You described it as a tipping point, Mr. Chair, and that is what the Latino community faces today and in the future. As our community grows, we will reach critical mass in jurisdiction after jurisdiction across the country, hundreds of them at a time. Now, many of those jurisdictions will react appropriately to the growth in the Latino population and not take steps to suppress votes. But too many of them will perceive a threat to those currently in power by the growth of the Latino community and will engage in vote suppression measures. We have to, as a nation, be able to address those threats effectively. We cannot address so many threats across the country with a growing Latino community reaching that tipping point in hundreds of jurisdictions successfully if Section 2 is the only tool available. That is why preclearance is essential as we face this future where not just the Latino community but other communities reach critical mass and are perceived as a threat in jurisdiction after jurisdiction. The fact is that the ADR preclearance ensures that we can, as a nation, effectively not just prevent this vote suppression from occurring, but provide a clear message to other jurisdictions that it is not worth their taking a gamble of engaging in vote suppression, hoping that they won't be targeted for litigation under Section 2. The availability of preclearance ensures that they will understand that that's not a gamble worth taking. So it will also deter vote suppression in other circumstances. In closing, I assert what I have said publicly about this all along. Geographic coverage and practice-based coverage go together. If you want to address successfully vote suppressors across the country and prevent them from engaging in vote suppression, you have to target not just the serial vote suppressors, as a geographic coverage formula does, those with an established history of voting rights violations, but also the copycat vote suppressors, those new jurisdictions that have crossed that tipping point and react to that tipping point by engaging in vote suppression measures long established in other jurisdictions to violate voting rights. Thank you.
Thank you, sir. Our next witness is Mr. John C. Yang. Mr. Yang is President and Executive Director of Asian Americans Advancing Justice, otherwise known as AAJC, which seeks to advance the civil and human rights of Asian Americans and to build and promote a fair and equitable society for all through policy, advocacy, education, and litigation. He's a longtime leader in the Asian American Pacific Islander community, having founded the Asian Pacific American Legal Resource Center in 1997 and served as president of the National Asian Pacific American Bar Association. Also served in the Obama administration as a senior advisor for trade and strategic initiatives at the Commerce Department. Earlier this year, he testified before this subcommittee at our hearing on anti-Asian discrimination and violence, and that ended up helping produce good legislation. We thank you. Mr. Yang received his JD with honors from GW Law School here. He served as editor of the George Washington Law Review and as a member of the Moot Court Board. Received his BA from Washington University in St. Louis, Missouri. Mr. Yang, you're recognized for 5 minutes.
Thank you, Chairman Cohen, and thank you, Ranking Member Johnson, as well as the other members of the subcommittee. My name is John Yang. I'm the President and Executive Director of Asian Americans Advancing Justice, AAJC. The mission of our organization is to advance the civil and human rights of Asian Americans and to promote a fair and equitable society for all. I appreciate this opportunity to testify before you on this issue of importance to Asian Americans. Practice-based preclearance, in conjunction with the restored coverage formula, is critical to modernizing the Voting Rights Act to reflect the emerging political voice of the Asian American voters. In targeting those practices that have been used throughout history to silence the political voice of minority communities, just when they are beginning to reach critical mass and when they could begin to impact the outcome of elections, practice-based preclearance will ensure that the practice being proposed is not discriminatory and harmful to the minority community. These issues have special relevance for the Asian American community. According to the 2010 census, Asian Americans are the nation's fastest growing community, with a growth rate of 46% between 2000 and 2010. At that time, we numbered about 17.3 million Asian Americans in the United States. Now, after the 2020 census, we are approximately 23 million of the American population. While the Asian American population has increased exponentially in the last 50 years, our community also has been part of the American fabric for centuries, whether as railroad workers in building the Transcontinental Railroad, whether as Japanese American soldiers in the most decorated World War II U.S. combat regiment, whether it is working on farms or on the front line as healthcare workers during COVID-19. Nevertheless, Asian Americans are still perceived as outsiders, foreigners, aliens. Indeed, we have seen this exponential rise in anti-Asian hate over the last 18 months because of the scapegoating of Asian Americans as foreign, disease-carrying, and somehow a threat to America. Because of this view of Asian Americans as the foreigner, we have been denied rights held by U.S. citizens, including the ability to vote, for most of the country's existence until significant changes were made in the 1940s and then with the culmination of the Immigration and Nationality Act of 1965. Prior to such reforms, Asian Americans were excluded from civic participation, often driven by that fear of the other and the potential threat to the political livelihood of those in power. This is not only a problem of the past, but it is one that rears its ugly head in the present day, and one that is poised to become even bigger because of the demographic shifts that I have mentioned above. Asian Americans are becoming more politically visible, more politically viable in new jurisdictions throughout the country, including in unlikely places such as North Carolina, Georgia, Nevada, and Arizona. With this growth is an increase in racial appeals against Asian American candidates and efforts to erect barriers to the ballot for Asian American voters. For example, during a 2009 Texas State House of Representatives hearing, a legislator suggested that Asian American voters adopt names that are easier for Americans to deal with in order to avoid difficulties imposed on them by voter identification laws. This statement, among other things, casts Asian Americans apart from other Americans simply because of names that may sound foreign to those individuals. Similarly, in a 2004 primary election in Alabama, supporters of a white incumbent facing a Vietnamese American opponent challenged the eligibility of only Asian Americans at the polls by falsely accusing them of not being U.S. citizens or city residents or having felony convictions. The losing incumbent's rationale was, if they couldn't speak good English, they possibly weren't American citizens. DOJ's investigation found the challenges racially motivated and prohibited interference from the challengers during the general election. As the testimony from others demonstrate today, praxis-based preclearance focuses on those practices that have been shown to be used to silence the political voice of a growing and emerging community of color. These practices include voter identification laws, withdrawal of multilingual support, and the reduction of polling places. The U.S. Census Bureau forecasts that while the number of Asian American immigrants will grow between now and 2040, the proportion of Asian Americans who are immigrants will decrease, and that there will be a very high naturalization rate and an increase in U.S.-born Asian Americans in the coming years. Voter participation rates in the Asian American community is growing steadily and very quickly, and indeed, its political visibility will only increase. It is precisely for these reasons that restoring and strengthening the Voting Rights Act is a top priority for our organization. Thank you very much.
Thank you, Mr. Yang. What state was that said the question about if you can't speak English, you shouldn't be able to, good English, you shouldn't be able to vote?
That was in Alabama, that they used the term
wow.
good English.
That's kind of ironic. Our next witness is Mrs. Lewis. Well, I guess we're going to the remote, is that right? Our next witness is Louis Fraga. He's the Reverend Donald P. McNeil, Professor of Transformative Latino Leadership, Joseph and Elizabeth Roby, Professor of Political Science, Director of the Institute for Latino Studies, and Fellow with the Institute for Educational Initiatives at the University of Notre Dame. His primary interests are in American politics, where he specializes in Latino politics, voting rights, immigration, and education. He's published 6 books, 40 articles in scholarly journals, and edited volumes. Most recent He most recently co-edited books is Latinos in the 2016 election, Latino Resistance in the Election of Donald Trump, published in 2020. Prior to the teaching at Notre Dame, he taught at Stanford for 16 years. Professor Frege received his PhD and MA from Rice and is an AB cum laude from Harvard. Professor Frege, you're recognized for 5 minutes. You need to turn on your, we can't hear you.
Maybe if I turn on my microphone, that'll work.
It always
Thank you, Mr.
works.
Chairman, ranking member of the committee, and other members of the committee. There's a long history of voter suppression, including vote dilution and voter disenfranchisement in the history of the United States. At times, there were specific groups that were the targets of these efforts, including immigrants, African Americans, Latinos, Asian Americans, Native Americans, other language minorities, and women. Other times, such targeting occurred behind the required payment of property taxes, poll taxes, literacy tests, or convictions for a felony. What is significant about these efforts is that they were in almost every instance enacted by efforts designed to maintain groups in power by excluding others. Those groups were, most often, white males. It is also important to understand that when successful efforts were pursued to fully enfranchise a previously excluded group, those who perceived themselves to have lost or who now had to share power often worked actively to reverse that enfranchisement. Success, in other words, has rarely been maintained. Retrenchment and reaction have often led to backsliding that required even greater efforts to overcome policies and practices of dilution and disenfranchisement. In the report that I submitted to the committee, I discuss a history of the presence of efforts at voter suppression, with a special emphasis on vote dilution and disenfranchisement in the history of the United States. This is done to provide analytical background to more comprehensively understand the continuing need for governments, national, state, and local, to actively work to overcome laws, policies, and practices that suppress voters' capacities to cast a meaningful vote and to cast a vote at all. This history can also be used to understand that current efforts that lead to voter suppression build and often replicate what has been done in the nation's past. One can say that historical legacy may, in fact, not be a legacy of the past, but rather a current manifestation of that past legacy. It is also the case that judicial endorsement of the expansion of voting rights has been uneven and oftentimes not long-lasting. For example, the Supreme Court in Shaw v. Reno in 1993 and Shelby County v. Holder in 2013 changed court precedent most recently. What is learned from the history of the United States is that without a clear, strong commitment on the part of the federal government, one cannot depend on state and local jurisdictions to protect the voting rights of racial, ethnic, language minority, and other historically marginalized voters. This history must be remembered as Congress considers amending Section 4 of the Voting Rights Act to focus on practices that lead to disenfranchisement and vote dilution throughout the country. Such practices, as we know, can be overt as well as subtle. Whatever clarity can be provided by the rewriting of Section 4 will work to enhance the likelihood that all voters will have an equal chance to vote and to cast a meaningful vote. Only then will one of the most fundamental ideals of American democracy have the chance to be realized. Thank you, Mr. Chairman.
Thank you, Professor. And I think, is it Fraga?
Fraga, yes.
Yeah, I got it right this time. Thank you.
You're very welcome.
Sorry about the first time. Our next witness, is our next witness related to you, Professor Fraga?
He is my son.
Good work. Our next witness is Bernard Fraga, Associate Professor of Political Science at Emory University. His research interests are in the areas of American electoral politics, racial and ethnic politics, and political behavior. Broadly, he studies how group identities and electoral context impact individual political behavior. His methodology tends toward the statistical analysis of observational data associated with voter registration records and election results. He also conducts research on election law and electoral institutions in the United States. He teaches graduate and undergraduate courses on American elections, racial, ethnic politics in the United States, and political science research methods. Professor Fraga received his PhD and MA, says here AM, I guess they call it an AM instead of an MA, from Harvard University, and his BA from Stanford University. Professor, you win the Good Son Award. You're recognized for 5 minutes.
Thank you so much, Chair Cohen and Ranking Member Johnson, and other distinguished members of the committee. It's an honor to testify before you today. My name is Bernard Fraga, and I'm an associate professor of political science at Emory University in Atlanta, Georgia. I was asked to provide testimony regarding the need to enhance the Voting Rights Act via election practice-based coverage. My peer-reviewed research focuses on the quantitative analysis of elections in the United States, including the assessment of racial, ethnic, and other demographic differences in voter turnout, office seeking, and election outcomes in both contemporary and historical context. Now, when I teach my graduate and undergraduate students about American elections, one of the first things that I note is that state and local election laws, and in particular, the presence or absence of federal oversight of such laws, can have a dramatic impact on whose voices are heard in American democracy. Nothing indicates the important role the federal government, especially Congress, can play in enhancing our electoral process better than the Voting Rights Act of 1965. However, a powerful tool of the act for combating efforts to restrict the right to vote was rendered inactive after the Shelby County v. Holder decision in 2013. In that decision, the pre-clearance provisions of the Voting Rights Act were ruled inoperable, as the coverage formula was deemed unconstitutional. Chief Justice Roberts noted that while, quote, voting discrimination still exists, no one doubts that, end quote, Congress needed to, quote, draft another formula based on current conditions. Now, in preparation for today's testimony and with an eye towards drafting such a formula, I analyzed historical, theoretical, and empirical evidence regarding where and when voting rights violations were most likely to occur. This included using a database of thousands of voting rights lawsuits nationwide and detailed demographic data on states and counties over the past 4 decades. In my analysis, I found the following. First, historical evidence clearly indicates that in states and counties with a larger minority population percentage, efforts to limit the electoral participation of racial ethnic minority citizens are substantial and persist absent federal intervention. This is true even when looking within the Deep South during the height of Jim Crow. Counties with a larger Black population were the last holdouts to allowing Black citizens to register, as we saw in dramatic fashion on Bloody Sunday. I found a similar pattern in heavily Latino and Native American areas of the Southwest. This is exactly why the Voting Rights Act was so important and remains so important today. Second, since passage of the Voting Rights Act, suits alleging violations of minority voting rights are more common in states and counties with sizable racial ethnic minority populations as compared to states or counties with smaller minority population shares. Just to give you a sense of the numbers here, roughly 2/3 of counties where a minority group makes up more than 20% of the voting age population have had at least one voting rights related lawsuit filed against them since 1982. This is about 4 times the rate we see in counties with a smaller minority population share. Finally, when combined with a practice-based approach to preclearance, limiting this preclearance to areas where at least 2 racial ethnic groups make up 20% or more of the state's or county's population balances the trade-off between protecting voting rights on the one hand and creating additional requirements for election officials on the other hand. Jurisdictions meeting this population criteria are more likely than not to have had at least one violation of voting rights in recent decades. In my professional opinion, therefore, this population-limited approach to practice-based preclearance would ensure the most just and most efficient allocation of federal legal resources possible to protect voting rights. This formula would also meet Chief Justice Roberts' call for a formula imposing current burdens based on current needs and current conditions. In closing, I urge the committee to reinvigorate the Voting Rights Act and renew the promise of voting rights for all Americans. Thank you very much, and I look forward to your questions.
You're welcome, Professor. Our next witness is Mr. T. Russell Noble. Is that correct? Nobel. Mr. Nobel is a senior attorney with Judicial Watch, Inc. From 2005 to 2012, he served as a trial attorney in the Civil Rights Division of the U.S. Department of Justice, including 5 years in the division's voting section. He also previously was legislative assistant for a member of the House Financial Services Committee. Mr. Nobel received his JD from Mississippi College School of Law and his BA from the University of Mississippi. He served as a law clerk at the Supreme Court of Mississippi, and you are recognized for 5 minutes, sir.
All right. Thank you. Thanks. Good afternoon, Chair Cohen and Ranking Member Johnson and other members of the subcommittee. Thank you for having me here today to testify. H.R. 4 includes 2 separate preclearance coverage provisions, each requiring separate and independent justifications. That is, H.R. 4's practice-based coverage cannot rest on the same generalized showings that will be assembled in support of H.R. 4's new Section 5 geographic coverage formula. One needed showing in that will be that the current racial disparities in voting are materially worse than those from 1965, and that such disparities justify a new practice-based coverage. This will be a difficult task. A future review by the Supreme Court will focus on minority ballot access and whether the DOJ can effectively combat discrimination in 21 via litigation. Current data shows that racial disparities in voting have been dramatically reduced or eliminated in many states across the country. Considering that black registration and turnout exceeds white in some Section 5 jurisdictions, proponents will have a difficult time showing that 2021 disparities necessitate a 1965 remedy. The argument that H.R. 4 conserves DOJ resources fares no better. DOJ's own data shows that most of the practices covered by H.R. 4 have only led to 14 lawsuits in the last 10 years, hardly a rate that strains department resources. Many reports circulating in support of H.R. 4 include inflated enforcement statistics that often lump together counts of private enforcement actions as proof of rampant discrimination. But the Supreme Court does not view private suits the same as it does DOJ suits. In general, private discrimination lawsuits are a poor measure for determining the amount of discrimination occurring and can be misleading. The problem for H.R. 4 proponents is clear. Despite relentless claims of suppression by the media and academia, the data shows that minority registration and turnout continues to improve, and in many instances eliminating meaningful disparities in many states. This undeniable trend has led to shifting voter suppression narratives over the last year, showing that H.R. 4 proponents are still searching for a theory to explain their opposition to state laws they simply just don't like. H.R. 4 is a remedy in search of a problem. Just in the last 3 months, there's been dramatic shifts, and they've been significant. For example, shortly after a public poll showed that 80% of Americans support voter ID, the majority whip publicly stated that he's always supported voter ID. This is obviously a paradigm shift to anyone that follows election law policy. Another recent shift involves the Postal Service. For the last 10+ years, there's been a public campaign to promote in states a vote-by-mail system, electoral systems, despite obvious security risk. The primary argument in support of these systems is that the use of the Postal Service will increase franchise. Yet, just 3 weeks ago, in her Brnovich dissent, Justice Kagan found that requiring Native American voters to use the Postal Service could lead to disenfranchisement. A third shift also comes out of Arizona. During last November's election, many ignored or mocked concerns about ballot chain of custody and the handling of uncounted ballots during the Georgia certification process. Yet, just last month, the DOJ wrote to Arizona alleging that improper handling and inadequate chain of custody controls of already counted ballots in the audit potentially would intimidate voters. There are a lot of reports being circulated to explain voter suppression in 2021, but the world did not need 10,000-word reports to explain Jim Crow suppression in 1965. Everyone in this hearing, I believe, knows what Jim Crow involved. It was state-sponsored oppression of its citizens, and in several instances, much worse. For that reason, it's mystifying that some smear reasonable, common-sense election regulations as Jim Crow 2.0. Such glib comments suggest that speakers neither understand Jim Crow 1.0 nor election regulations. Jim Crow is not a brand, it's not a software update. It's a dark period in our history that is invoked often to inflame passions. Efforts to label common sense election integrity regulations as Jim Crow suggests that some see they are losing the rhetorical battle on election regulation. But ballot access data provides clear hope. Despite relentless voter suppression claims over the last 15 years, minority registration and turnout has continued to increase while racial disparities have dramatically decreased. Thank you very much for inviting me to testify, and I look forward to answering your questions.
Thank you, sir. Our next witness is Mr. Brian Tyson. Mr. Tyson is a partner in the law firm of Taylor English Duma in Atlanta, Georgia. Primarily represents governments, candidates, and complies companies in election and campaign finance matters. Previously advised the Georgia General Assembly during his 2011 redistricting process. Was appointed as Special Assistant Attorney General to assist in securing federal approval of all 3 redistricting plans adopted by the legislature during that special session. He also previously served as policy aide to the former Congressman Len Westmoreland of Georgia. Received a J.D. magna cum laude from Oak Brook College of Law. Mr. Tyson, you're recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Johnson, members of the committee. It's a privilege to be with you today to discuss the provisions of practice-based coverage. I don't come to this as an academic. I come to this as a practitioner. I have worked both as an expert and a litigator in redistricting, election administration, and Voting Rights Act cases for right at 20 years. And so what I wanted to do today is share with you a practitioner's perspective on these practice-based components of preclearance and identify several issues for you. And I have to give the disclaimer as well that although I and my law firm represent a number of governmental clients in Voting Rights Act and election litigation, I'm speaking today in my personal capacity based on my perspective and experience and not on behalf of a client. So first, I think we all recognize that the Voting Rights Act of 1965 is one of the most significant pieces of legislation enacted by Congress to secure the voting rights of minority voters across the country. And without the Voting Rights Act and the special provisions that were included for a special time in our nation's history, a very dark time in our nation's history, we might not have ever effectively protected the right to vote for minority voters. And so the question today for the committee and what you're looking at is whether and what additional protections are needed beyond what still remains in force of the Voting Rights Act. After Shelby County, the Voting Rights Act retains significant force. Jurisdictions that engage in intentional racial discrimination can be brought under the preclearance regime under Section 3 by a court. Jurisdictions that reduce or dilute minority voting strength in violation of Section 2 face litigation with the strong incentive for plaintiffs that was referenced earlier, full recovery of attorney and expert fees. And those of us in Georgia have seen there is no shortage of individuals and groups who are willing to litigate about election administration, especially in our state. And in contrast, what we have in H.R. 4's practice-based coverage is the idea that elections should be federalized by injecting the federal government into these intensely local questions of election administration because it covers practices that are extremely broad. So in my prepared remarks, I referenced the difficulties and burdens around the preclearance process. And I think, again, as the committee considers placing the types of the obligations on jurisdictions, the burden and difficulty of submitting for preclearance is a major factor in that. For the specific practices the committee's considering, both the redistricting and the jurisdictional boundary practices pick particular racial numbers at which preclearance is required. But again, these are areas where Section 2 more than addresses that need. And that's especially true when the redistricting section is written in such a way that it's not narrowly tailored at all. It's extremely broad in terms of which jurisdictions it will capture, almost every redistricting undertaken by most jurisdictions in the country. Then there are several practices in the proposed legislation that are singled out with an apparent partisan lens. For example, the documentation or qualifications to vote has no racial category limitation. So any provision adding photo ID, for example, is covered, despite the fact, as was referenced earlier, that large majorities of voters of all races and political parties support photo identification laws. Changes to list maintenance are similar. List maintenance is required by federal law. So this legislation is apparently seeking to freeze in place whatever a state is currently doing in its list maintenance process. We've litigated list maintenance in Georgia, challenges under both the NVRA and challenges under the constitutional burden on the right to vote. And our process in Georgia was upheld in those challenges. There's no reason to think that similar challenges to list maintenance would need this extraordinary burden of preclearance and couldn't be handled through the normal course of litigation. And finally, the provisions for changing voting locations and opportunities to vote is incredibly broad. Decisions about voting locations and voting hours in Georgia are charged primarily to local election officials. State officials play no role in those decisions. And these types of limitations would also capture a lot of innocent conduct. Counties sometimes close polling places because of budget considerations or disability access issues. And this would subject those types of decisions to preclearance. The continued increases in early voting that we see across the country likewise reduce the strain on election day polling sites and mitigate the need to have kind of a case-by-case review of these. So protecting voting rights is critically important, but H.R. 4 as it currently has the practice-based provisions will ultimately undermine the purposes of the Voting Rights Act. It includes a number of provisions that will adversely affect the ability of states and local jurisdictions to effectively operate elections, codifies this federal takeover of elections, and opens the door to the partisan use of the preclearance process instead of protecting voting rights. So as we'll discuss, existing law covers the areas that are covered by the practice-based coverage components of the bill, and there are not extraordinary circumstances which require this massive federal intervention. I look forward to answering your questions and appreciate the time today. Thank you.
Thank you, Mr. Tyson. Our final witness is Bernita Tolson. She's Vice Dean for Faculty and Academic Affairs and Professor of Law at the University of Southern California Gould School of Law, where she teaches a course on con law and election law. She's written on a wide range of topics, including partisan gerrymandering, campaign finance reform, the Elections Clause, the Voting Rights Act of '65, and the 14th and 15th Amendments. Her research also has appeared in leading law reviews, including Boston University Law Review, the Vanderbilt Law Review, the Alabama Law Review, the Notre Dame Law Review, and not in the top 15 of football schools, the University of Pennsylvania Law Review online. Professor Tolson received her JD from the University of Chicago Law School, where she served as a member of the University of Chicago Law Review. She did BA cum laude from Truman State University. She served as law clerk for the Honorable Ann Claire Williams of the United States Court of Appeals for the Seventh Circuit, and the Honorable Ruben Castillo of the Northern District of Illinois. Professor Tolson, you're recognized for 5 minutes.
Thank you, Chairman Cohen, to the Chairman and Ranking Member Johnson, as well as the distinguished members of the subcommittee. Thank you for the opportunity to appear and speak about the practice-based coverage provision of H.R. 4. It is beyond dispute that voting rights are under assault, and this provision is a necessary step towards restoring the protections of the Voting Rights Act. The Supreme Court's decision in Shelby County versus Holder hobbled the preclearance regime that would have prevented a number of states from passing these new voting restrictions by requiring them to submit these changes to the federal government for approval before they could take effect. Importantly, the Shelby County decision tried to paint pervasive voting discrimination as a relic of a time long past, ignoring that legislators often fall back on certain practices to diminish the political power of minority communities. By singling out certain electoral schemes that disenfranchise and or minimize minority political power, practice-based preclearance updates the provisions that would trigger federal oversight of state electoral systems. From the long eradicated practices like the polls hacks and literacy tests heavily criticized by the Shelby County Court, to techniques that have been consistently used and importantly are still being used by states to disenfranchise minority voters. Shelby County notwithstanding, Congress retains substantial authority under the 14th and 15th Amendments, as well as the Elections Clause, to pass the practice-based preclearance provision of H.R. 4. Notably, the Shelby County Court read both the 14th and 15th Amendments to require Congress to establish a pattern of intentionally discriminatory action on the part of the states as a prerequisite for reauthorizing the original coverage formula of Section 4B. This view misrepresents prior case law. Initially, the Supreme Court broadly interpreted Congress's power to enforce the 15th Amendment in both South Carolina versus Katzenbach and City of Rome versus United States, which rejected the argument that Congress's enforcement power under the 15th Amendment was limited to remedying only intentional racial discrimination, and read that authority to be as broad as the necessary and proper clause of Article 1. Similar to the 15th Amendment, the court had also described Congress's enforcement power under Section 5 of the 14th Amendment as broader than the judicial power to define the substantive scope of Section 1 of the amendment, but the court narrowed this authority in a case called City of Berney versus Flores. According to City of Berney, Congress's enforcement power is limited to remedial fixes and does not include the ability to make substantive changes to the scope of the 14th Amendment. But there are two important takeaways from City of Berney as it pertains to Congress's authority to protect the right to vote under the 14th and 15th Amendments. First, Shelby County never determined whether City of Berney's rationale also applies to the 15th Amendment, leaving in place Congress's broad authority to enforce that provision as articulated in City of Rome and Katzenbach. Second, while the court's decision in City of Berney sharply circumscribed Congress's ability to enforce the 14th Amendment, it remains true after the decision that intentional discrimination is not a necessary prerequisite to a 14th Amendment violation. In Harper versus Virginia State Board of Elections, the court held that the Equal Protection Clause of the 14th Amendment protects a fundamental right to vote that is distinct from the 15th Amendment's prohibition on racial discrimination in voting. The 14th Amendment separately authorizes Congress to target practices, either discriminatory or non-discriminatory, that undermine the fundamental right to vote in local, state, and federal elections. Congress also has broad authority to enact practice-based preclearance pursuant to the Elections Clause, which empowers states to choose the time, places, and manner of federal elections, but importantly, reserves to Congress the power to make or alter state electoral schemes. The court, in assessing the constitutionality of the coverage formula of Section 4B in Shelby County, ignored how the Elections Clause, as a potential source of authority for the Voting Rights Act, mitigated the federalism concerns raised by the statute. Under the clause, Congress has the authority to alter state law where appropriate, make law completely independent of the state's legal regime, and commandeer state officials to implement federal law. This structure permits Congress to enact a complete code for federal elections, which is an invaluable source of authority, particularly if states have jeopardized the health and vitality of federal elections in some way. Indeed, the practice-based preclearance provision isolates those practices that states have historically used to abridge or deny the right to vote, and it does so without singling out any particular jurisdiction or geographic area. Congress's power under the 14th and 15th Amendments, as well as the Elections Clause, provides sufficient authorization for H.R. 4 because those provisions empower Congress to enact legislation seeking to prevent local, state, and federal election regulations that abridge or deny the right to vote or that have a racially discriminatory impact. Thank you. I welcome your questions.
Thank you, Ms. Tolson. Now go to the question periods of 5 minutes each to ask questions, and I will recognize myself for 5 minutes. Let me start with Mr. Yang. You've read Shelby v. Holder, and you've read the more recent case with Brnovich. What would you advise this committee to do to come up with a law, a voting rights amendment that will withstand Supreme Court challenge?
Well, certainly by holding these hearings is very important to establish the record of discrimination, of the need for the practices, known practices coverage that we're talking about here today. One thing that I would also offer is that the question here is not whether there is less discrimination than when the Voting Rights Act was passed in 1965, but whether there is discrimination that still needs to be addressed. And again, that is why the need for an extensive record, the hearings that you are holding, is relevant to what we are doing today.
The hearings, obviously, and we need to have a record, but do you think there's any geographic designations that we could come up with that would satisfy the justices?
I think I would actually defer to Mr. Science to talk a little bit more in depth about that,
Sure,
but
he's
certainly.
nodding, so he obviously wants to respond.
Right, that's right. But certainly we can. And I think this is also where it's important to have what we have been talking about in terms of complementary coverage with both the pre-clearance, the known practices coverage, as long as the geographic coverage.
Professor?
Yes, I think you can come up with a geographic coverage formula that would pass muster. The Shelby County majority, as you know, expressed concerns about equal sovereignty and about federalism, and they expressed concerns that the coverage formula that had existed for so long when the case came to them did not reflect current conditions. I think it's clear if you have a formula, a geographic formula that is based on adjudications of voting rights violations in that specific jurisdiction, that is a reflection of current conditions. It is also the kind of violation, as we see with Section 3, where a court can order bail in, it's also the kind of violation that warrants the intrusion on federalism that the majority was concerned about in Shelby County. And it is also respectful of equal sovereignty because every state that engages in the number of violations provided in the legislation that you enact would be subject to preclearance, whether they're in any region of the country.
Thank you. Professor Tolson, Congress, as a matter of longstanding constitutional interpretation, should have broad authority to ensure all Americans guaranteed equal opportunity to vote, free from discrimination in all ways. But we've seen a number of decisions from the Supreme Court, Shelby v. Holder, the first, that seem to go out of their way to try to limit that broad authority, even while leaving those broad precedents undisturbed. In light of this, how confident can we be that this current Supreme Court would uphold a practice-based coverage formula based on existing precedents interpreting the Reconstruction Amendments in the Elections Clause?
Thank you, Chairman. I don't think anything is certain, but you can definitely make it harder for them. Because one thing that we have to stop doing is lumping the 14th and 15th Amendment together. I think when we do that, it sort of blurs the lines between what Congress can and cannot do. Another thing Congress can do is be explicit about the sources of authority that it is relying on. And that way, when the record goes before the justices, they have to be clear in articulating why the new coverage formula is unconstitutional. So, for example, let me give you a sense of what this means. The Shelby County decision seems to indicate that the record has to show intentional discrimination on the part of the states in order for it to be sufficient to justify the coverage formula. That's only part of the story if you're relying on the 15th Amendment. The 14th Amendment also protects a fundamental right to vote, which means that the record can show abridgment or denials of the right to vote, even in the absence of intentional discrimination. Even more importantly, the Elections Clause doesn't require either, right? Congress can make or alter state law. And they can do so without any justification, especially where states have jeopardized the health and wellness of federal elections. And so that is that's a much different record than the record that was before the court in 2013.
Thank you. Professor Fraga, the senior, the father, what can history and demographics teach us about the likelihood that certain jurisdictions will turn to voter suppression efforts, particularly in places where jurisdiction may not otherwise have a long history of having engaged in voting rights violations?
Part of what I was trying to get across, Mr. Chairman, was that this history of voter suppression and efforts like the implementation of at-large elections have occurred in many different parts of the country, targeted at different groups and at different times. So what I'm trying to get across in that consideration in response to your question is that it's very important that there be continued vigilance, because every time that vigilance has been removed, every time that enforcement efforts to protect voting rights have been removed, every single time in the history of our country, there has been an equivalent movement to try to limit the voting rights of particular segments of our population. That vigilance I see as being possible and absolutely necessary when we reconsider the nature of Section 4.
Thank you, sir. Now recognize Mr. Johnson for 5 minutes.
I thank the chairman, thank all the witnesses again. Let me begin with Mr. Nobile. I just want to ask you a very simple question because there seems to be a lot of confusion about this and debate in the country, and depending upon which news program you watch, you may have a different opinion, but you're an expert on it. Is there widespread voter suppression in this country today?
No.
Explain that a little bit more. I know you did in your testimony, but we have to repeat it over and over.
Yeah. I mean, look, in Shelby, in the cases, you have to look at the actual ballot access data. And turnout and registration are pretty, or tell most of the story, right? I mean, Justice Kagan in her dissent last week or 3 weeks ago said something to the effect of, if people don't turn out, so be it. And Justice Kagan is 100% right in her dissent. Unfortunately, that's not how a lot of the advocates feel. They feel like if there's not a turnout, then there must be some problem. And problems with turnout are sometimes, or usually, completely unrelated to regulations and time, place, and manner regulations.
And the intent of the legislature or the officials in charge, right?
Correct.
Why is the administration, do you think, highlighting Georgia and Texas as examples of states pushing so-called voter suppression and not other states, I don't know, say those run by Democrats that have had virtually identical laws on the books for many years?
I mean, I haven't done a full survey, but I suspect if you go back the last 30 years and look at every purple state, you'd see all the claims arising there. So states where they feel like they can flip is going to be where resources are poured into. And that's why private suits are not really that helpful in determining local discrimination. It's really just who's got the most money and who has the most lawyers willing to bring a Section 2 case. And honestly, that's not a very high bar. There's lots of money out there. There's lots of lawyers willing to take a Section 2 case. And that's going to really determine where the most cases are brought.
So it looks like a brazen political agenda, does it not?
Yeah, I mean, it's you want to get your vote out. You want to drive up your base. I mean, you want to show people that you're fighting in there for their votes, and so it's trying to get people to turn out and trying to get support generated in whatever state you're trying, or region or municipality that you're trying to flip.
Very good. My colleague, Representative Owens, said in a previous hearing here that it is offensive to those who actually lived through the Jim Crow era to equate today's voting measures to that. And as you summarized, I thought really well, Jim Crow is not a mere brand or a slogan. I think it's just thrown around today and people don't understand the import of that.
It's really, I mean, honestly, I'm not here to give a moral lesson on anything, but it's really shocking that Jim Crow gets thrown around the way it does. I mean, everyone knows what Jim Crow is. It's a dark part of our history. I mean, I've brought civil rights cases. I brought the case against involving Prairie View A&M students in Waller County, Texas. I've brought cases on behalf of minority plaintiffs, and it's quite troubling the way that just gets thrown around because, I mean, it's a dark time in our history, and you wouldn't do that with other things. And I'm not going to draw parallels from international history, but we're all aware of them, and you wouldn't throw those around to try to inflame people's passions or to try to win your rhetorical argument.
I just want to disagree with you on one point. I don't think everybody does understand what Jim Crow really was and the dark era that it was in our nation because they use it so casually. Let me go. I'm running out of time. Mr. Tyson, thank you for your testimony today. What other provisions currently exist within the Voting Rights Act and other federal statutes that adequately address states that violate the Constitution by engaging in voter discrimination? You touched on this a little bit, but it was said just a few moments ago, we have to be continually vigilant. Can't we do that without this new legislation?
Absolutely. And I think that's one thing that we've seen very clearly, especially in 2018, 2019, 2020 in Georgia. There's been no hesitancy and no lack of effort in bringing litigation about a variety of election practices. And that's true under the fundamental right to vote claims. That's true under Section 2. That's true under the Civil Rights Act and other claims that were there. There are a variety of methods to use, and we've seen plaintiffs have not been hesitant to use those at all in suing when they believe that something is going wrong with election administration.
So if this were to pass, how do you expect the proposed coverage formula would play out, considering that it would require all jurisdictions to be subject to preclearance in certain circumstances, and I think more problematic, it would allow outside groups to file enforcement actions against states? Is that a recipe for disaster?
I think it is, and especially the broad definition of a voting rights violation in the current version of the draft the committee has. It includes things that are so broad, there will be incentives for private groups to go sue states that they want to pull under preclearance, and then ultimately, again, that leads to the danger of partisan enforcement. Voting rights are too important to be given over to a partisan political agenda.
Very good. I'm unfortunately out of time. I yield back.
Thank you, Mr. Johnson. Ms. Ross from North Carolina is recognized now for 5 minutes.
Thank you so much, Mr. Chairman, and thank you so much to our witnesses. This has been a really great hearing. I am from North Carolina and was a state legislator when we expanded voting rights and a state legislator when we watched them get shut down or attempt to get shut down. I've also brought voting rights cases myself as a civil rights lawyer. I want to talk briefly about racial gerrymandering in North Carolina. In 2016, our state legislature created new congressional maps. This was after having them struck down that gerrymandered the state on an implicitly racial basis. The bill divided the campus of North Carolina Agricultural and Technical State University, the largest HBCU in the country, into 2 separate districts. The scheme diluted the votes of thousands of young African-American voters. However, in 2020, new maps were redrawn after a long period of litigation, and NCA&T's campus is now consolidated into 1 district. And amazingly, voter turnout on campus increased substantially in 2020 once that community of interest was brought together. Practices like this one that divide and diminish the power of minority voters are known to be discriminatory in nature. We need to remedy those violations in a way that doesn't require years of litigation. I'd also like to remind this committee that the pre-clearance formula in the Voting Rights Act of 1965 covered several counties in North Carolina, but not the state as a whole. And North Carolina's monster voter suppression law that targeted African Americans with surgical precision potentially could have been enacted even before the Shelby County decision because the entire state was not subject to pre-clearance. That law would have restricted early voting, imposed discriminatory voter ID requirements, repealed same-day voter registration at early voting sites, and even more. These are all known practices that are being considered again in many states today and in North Carolina and should be prevented at the outset. I'm grateful to all of you for your testimony on the need and legal basis for known practice coverage. My first question is for Professor Bernard Fraga. In your written testimony, you observed that the historical record of minority voting rights indicates periods of expansion, contraction, and then expansion that directly coincides with federal action to prevent states from de jure and de facto racial and ethnic discrimination in voting. Would you agree that since the Civil War, minority voting rights have only been protected due to active efforts by the federal government, and that the Voting Rights Act has been critical to preventing a backsliding on voting rights?
Thank you, Representative Ross. I think that's a very, very important point to make. Federal action is what has sustained voting rights, even despite the 14th and 15th Amendments, right? And the lack of federal action that we saw after the Reconstruction period during the Redeemer movement, right? The lack of Congress specifically taking action to counter some Supreme Court decisions and the actions of Southern states is what led to Jim Crow. So when we talk about Jim Crow and we talk about not recognizing the history of Jim Crow, I think we are not recognizing the origin of Jim Crow, which is a lack of federal action, congressional action specifically, to ensure that African American men at the time maintain the right to vote.
Thank you very much. And to your dad, Professor Fraga, in your view, are there common historical conditions that explain why politically dominant whites have resorted to the same voting practices to limit the voting strength of ethnic and racial minorities at different times and places throughout American history?
Yes, and I think the primary one is the competitiveness of statewide elections and the way in which, and this happened throughout the period before the formalization of Jim Crow. This is the period of dilution right after over 500,000 African Americans voted and elected members to local office and to Congress and to state office, and even 2 senators from Mississippi. The concern was, how do we make sure that they don't get a majority and keep a majority, given the closeness of the election? And so a series of procedures were used. I try to outline a number of them in my report to make sure that the numbers never constituted a majority. Same thing was done at state legislative levels. Same thing was done at the city level. And it is this sense of partisan competition, if you will, the sense of partisan competition that made the efforts race targeted, because the way in which these two factors intersect. And the parallel that I see is that there is great concern that the small margins that characterize election outcomes can be affected by current voter suppression methods.
Thank you,
Thank you
Professor,
very
and thank
much,
you
and
for,
I yield back.
thank you, Representative Ross. Now recognize gentleman from California, thoughtful conservative, Mr. McClintock.
Well, thank you, Mr. Chairman. Mr. Nobile, doesn't every fraudulent vote disenfranchise a legitimate voter?
Yes.
Wouldn't you say that's the ultimate voter suppression?
It certainly dilutes, I mean, it dilutes everyone's vote, so yes.
So obviously it's incumbent upon us to have a process that makes fraud very difficult to commit. I mean, obviously we don't allow people to mail in drug tests, for example, for obvious reasons.
I mean, ballot stuffing is not just a euphemism, it's actually happened. That's why people use it as a euphemism.
By definition, in a democracy, somebody's always going to win and somebody is always going to lose. The success of democracy depends on the loser accepting the legitimacy of an election, does it not?
Correct.
So to do
And
so,
I would add in the public accepting, everyone accepting the legitimacy of the election.
yeah, but especially the loser.
Well, they're usually the ones that
That's
don't.
the hardest pill to swallow. So they've got to have confidence in the integrity of the vote. What have recent changes in election procedures done to the public's confidence in the integrity of the vote?
Well, I mean, I think the sustained opposition to seemingly benign, race-neutral time, place, and manner regulations have really sort of been troubling. I mean, you have, I think, Georgia trying to at least have someone monitoring, allowing access to a drop box for ballots during, business hours makes sense. You shouldn't have drop boxes open 24/7.
Well, I wonder about that because up until just a few years ago, our elections process was very simple. It was accepted over many, many generations. You registered to vote with an elections official. They were available at any fire station or library or municipal office, but you had to go face-to-face with somebody and swear you were who you said you were. There was a 30-day close of registration so that all parties could canvass the voters. Candidates knew exactly who they were talking to. Those who had moved or died could be removed from the rolls. And then we all waited until Election Day. That's why we called it Election Day. It was a single day after the entire campaign had concluded, after we had heard the entire debate. We all together, in what George Will once called the communion of democracy, went to our local polling place. It was usually in a neighbor's garage or a neighborhood grade school. We looked our neighbors in the eye as we identified ourselves, and they handed us our ballot. We brought our children along so that they could observe the process because we taught them how important that was to their country. Then we took that ballot immediately into a curtained booth where nobody could cajole or pressure or plead with us, and we cast our individual votes according to our own conscience. We then gave that ballot back to our neighbor who immediately put it in a locked ballot box. It was all done in a public place where all citizens from all parties could observe it. And then at 8 p.m., when the polls closed, we knew exactly how many votes had been cast, and by 10 p.m., we usually knew who won. In a close election, it might be midnight. Now, that's all been torn down by the left. Now you register to vote simultaneously with voting. It makes it impossible for parties to canvass. Superannuated registrations are rarely removed from the rolls. We then send ballots to everybody, every name on those rolls, followed up by ballot harvesters to collect those ballots. There's no chain of custody from the time the ballot's mailed until the ballot's returned. Ballots are not secret. Family members, spouses, caregivers, friends can all, and for that matter, party ballot harvesters can all cajole and pressure us. Those votes can be cast many weeks before the debate is over. What's that done to invite fraud? And what's that done to undermine confidence in the integrity of the vote?
Well, I mean, anytime you make a system more complex, there's more problems, right? And that's essentially what you've done. You've had election day go from election day to election month. You've delivered and brought the joy of showing up at the poll site to your house where people can come and try to pressure you into voting one way or the other in the form of a harvester. The Voting Rights Act, when it was originally passed and still exists, actually had a carve out saying, you know, your union boss or your union rep and your employer couldn't help you cast a ballot. And that's because even in 1965, people knew that certain groups would be subject to undue pressure or, you know, coerced, not because anything other than maybe they're poor or they need a job or they're a minority or they've got some reason. And so there is, you know, that's all created a problem.
Thank you, Mr. McClintock. Next would be Mr. Raskin, still not with us. Mr. Hank Johnson, are you out on bail? Mr. Johnson, you're recognized for 5 minutes.
I actually orchestrated an escape, and so I am here, and I want to thank the Constitution Subcommittee of the Judiciary Committee for having this very important hearing. The 15th, 19th, and 26th Amendments guarantee the right to vote, and if the right to vote is denied, those so deprived lose the ability to preserve all other constitutionally guaranteed rights, and our country becomes a democracy in name only. To paraphrase Justice Kagan, never before has a statute been as extraordinary, required more sacrifice, and done more to advance our democracy than the Voting Rights Act. And yet, the Supreme Court has treated this special statute worse than any other law passed by Congress, first by eviscerating Section 4 and thus castrating Section 5, and then in Brnovich, the court has sought to dismember the Voting Rights Act by applying a tourniquet to Section 2. The majority of the court appears to fear that the Voting Rights Act is too, quote, radical, end quote, that it will invalidate too many state voting laws. So the majority instead wrote its own set of rules in Brnovich, acting as both arbiter and legislator, and pretty much putting Justice Roberts, you know, calling balls and strikes for his own team. Professor Tolson, do you think it's fair to characterize the Roberts Court as hostile to the Voting Rights Act?
I think that characterization is a fair characterization. Shelby County often gets a lot of heat, but what you have really is a series of decisions that have undermined the scope of the Voting Rights Act, both Section 2 and prior to Shelby County, Section 5. So I think that's a fair characterization. And this is why I urge not only this committee, but Congress as a whole to be thorough with the legislative record and be clear about the source of congressional authority, because I do think that the court itself has not viewed the Voting Rights Act favorably. So it's really important to be careful, but the authorization is there. And so Congress can pass practice-based coverage as well as the geographic formula in H.R. 4.
Well, given that the court seemed to rewrite Section 2 and thus legislate from the bench and become a, quote, activist court right before our eyes, what approach would you suggest Congress take to avoid any future flawed readings by this activist court? And specifically, what should we be careful about when drafting this language of known practices coverage?
With respect to the practice-based preclearance, the current bill identifies those practices that really, 6 decades of experience has taught Congress are practices that state legislators often fall back on in order to abridge or deny minority voting rights, and indeed voting rights more generally, right? It depends on the political calculus, but minority groups are especially vulnerable when, for example, states redistrict, which they do every 10 years, or if a state if a state or a locality engages in an annexation or de-annexation and so on. Like there's case law, there are examples of these measures being used repeatedly in order to disenfranchise minority communities. In addition, the language assistance provisions of the Voting Rights Act are still good law, but states routinely violate those provisions, further showing that there needs to be some federal intervention here in order to protect language minorities. So the evidence is there. It's squarely in front of Congress and sort of urges and shows the need for further congressional action here. In terms of the court misinterpreting the scope of the Voting Rights Act, there clearly needs to be some Section 2 fix because the Brnovich decision in particular emphasizes the state's authority over elections, but ignores the disparities that were caused by the Arizona law, the out of precinct rule, as well as the ban on ballot collection. So by emphasizing the state over the right to vote, the Brnovich court really misconstrued congressional intent with respect to the update to Section 2 of the Voting Rights Act.
Thank you. What should we be careful about, Mr. Bernard Fraga, in drafting the language on the practice coverages?
Well, I think that we clearly need the record to be established, and that's what we're doing here today. But we also need to make sure that we're basing it on current conditions. So in my report, I outline a population limited practice-based preclearance. It says in places where we know history, even recent history, it's much more likely that things like redistricting will be used to discriminate against minority voters. Those are the places where resources should be devoted and attention, scrutiny needs to be paid going forward.
Thank you. My time is up, and I appreciate it, Mr. Chairman. I yield back.
Thank you, Mr. Johnson. Good to see you. Ms. Garcia, Texas judge and congressperson. 5 minutes.
Thank you, Mr. Chairman, and thank you for putting this group together. I feel like I should call them the Magnificent Seven because they really did do a good job of presenting all perspectives, and certainly I've known my friend Mr. Sines for many years and worked with Maldiv, so welcome back. Mr. Chairman, this subcommittee convenes once again to address the need to enhance the Voting Rights Act, and I, for one, think that we could have a hearing like this every month until we get this done. And I would have no problem with it because we know that the Constitution protects our right to vote. That is something that all of us should take very, very seriously. And the Constitution also provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. And that is really at play here also. Yet we continue to see an all-out assault on the American democracy based on lies and baseless claims. The GOP's current efforts are not about voter security. They are, in fact, about voter suppression. As Congress considers advancing the H.R. 4, we must ensure that growing communities whose primary language is not English are included and protected in the voting process. Barriers to voting, which systematically exclude minority voters with language barriers, only hinders our ability to provide equal protection and opportunity for all. These voter suppression tactics are visible in Texas, much to my dismay. It's almost embarrassing to acknowledge that Texas leads the country in voter discrimination complaints that have been sent to the Justice Department pre-Shelby and even after Shelby. Most of the cases that have come out with the discrimination come from Texas. In Harris County, we're a population greater than 26 states. We speak about 145 languages, but it's getting harder and harder to get access to the ballot. So this is especially true every election season. So Mr. Sines, you heard the Republican witness say that the H.R. 4, the Voting Rights Act, John Lewis Voting Rights Act was a remedy in search of a problem. Yet your organization, Maldiv, AAJC, and NALEO joined forces to conduct a study to look at the types of changes that are made that would be covered by the John Lewis Voting Rights Act in a practice-based preclearance formula. Could you just discuss a couple of examples of how to demonstrate the need?
Sure. I think, unfortunately, for the reasons you've said, these examples more often than not come out of Texas in MALDEF's experience. The first example that I would give is one of the very first changes after the Shelby County decision was handed down. Both of them came out of Texas. As you know, Texas state leadership indicated an intent to revise the voter ID provision to make it more difficult, and that was rendered possible by the Shelby County decision. But what I focus on in my written testimony and today is what the mayor of Pasadena, Texas did. He immediately announced that Shelby County enabled him to do what he had wanted to do for so long but couldn't when he knew that it would be subject to preclearance review. And that was to shift a city council of 8 districted members to 6 districted members and 2 at-large members.
And he publicly stated his intent.
He publicly stated his intent to act in reaction to Shelby County.
Right.
The whole purpose for doing that was because the Latino community in that city had reached critical mass and was on the verge of taking over a majority of the seats on the city council. So to prevent that, he put in place this reversion to at-large seats. That's one of the identified practices in known practices coverage, as you know.
Well, thank you. And now to Mr. Fraga from Emory. You said in your testimony that absent any congressional role, us getting involved in doing something, that the voices of a minority electorate would not be heard. Could you tell us specifically what you were referring to, and also, can you tell us exactly what you think or recommend that we should do and what our role should be?
So it's very clear after the Shelby v. Holder decision that Congress needs to play a role in updating the formula and bringing preclearance back in, making it valid once again, right? I mean, this is the charge that Congress received from Chief Justice Roberts. And I think that what we see over time, historically, but also in recent times, is that when a group is growing, threatens the existing power structure. And I don't mean threatened by other things, I mean threatening at the ballot box. That's democracy at work, and attempts to suppress the vote or dilute the vote are an effort to undermine democracy. And I think that's what I'm referring to there as it regards minority voters. It's that without congressional action, it will be easier and more common, of course, for minority voices to be silenced, especially growing minority groups like Latinos and Asian Americans.
Thank you, and Mr. Chairman, I believe my time has run out.
Yes, it has. Thank you. That concludes our questioning for the day. I want to thank our witnesses for appearing and for your testimony. It really was good.
Mr. Chairman, I forgot I needed to ask for unanimous consent to introduce a document for the record.
So granted.
Thank you.
Without objection. The Magnificent Seven, that was good. That was good. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. With that, the hearing is adjourned.